Hi, this is Jen Rubin, editor-in-chief of the Contrarian. It's my pleasure to have with us Kelsi Brown Corkran. She is the head of the Supreme Court practice at Georgetown University Law School. They're a group that does constitutional litigation of all types, and she is the lead counsel on an extraordinary case concerning religious liberty. Welcome, Kelsi. Tell us about the lawsuit that you filed on behalf of dozens of religious groups of various denominations, various faiths.
Thank you for having me. So this lawsuit was filed yesterday morning in the U.S. District Court for the District of Columbia. There are 27 plaintiffs, includes 12 denominational bodies and representatives, 4 regional denominational bodies, and then 11 religious associations, both interdenominational and denominational, all across the Christian and Jewish faiths. So I'll just start naming who comes to mind: United Methodist, Presbyterian, Quaker, Unitarian Universalist, Conservative Jewish Movement, Reform Jewish Movement, Reconstruction Jewish Movement. I just left off a bunch of others, but really an astonishing array of diverse religious views, and they came together, as we say at the beginning of our complaint, united on the foundational belief that all human beings, regardless of birthplace, are a child of God, worthy of love, respect, and care, which means that welcoming the immigrant is a core precept of their faith practices. And they brought this suit in response to the Department of Homeland Security's announcement that it was abandoning a policy that had been in place for 30 years, where ICE and CBP agents would not conduct immigration enforcement actions in or near places of worship, except in exigent circumstances. So by removing that policy, DHS essentially opened up places of worship to all sorts of immigration enforcement action. And so the suit challenges that under the First Amendment, the Religious Freedom Restoration Act, and also the Administrative Procedures Act.
For decades now, the Homeland Security has taken the position that in an ordinary enforcement action, we're not talking about chasing someone who's dangerous, we're not talking about someone in flight, we're simply talking about, for lack of a better term, a raid of some type. They have some reason to believe that someone with a immigration status issue is inside a church. They would not barge into a church. They would not interrupt those services. They would not go in to pluck someone out. That even if they knew of the individual, they could certainly wait. They could certainly encounter the other person, arrest them someplace else. But they did not go into churches. And the reasoning, it seems, under the First Amendment is that it's an undue burden on religious belief. Talk to us a little bit about both the statute that you mentioned, which has been supported very strongly by Republicans as well as Democrats, and also the First Amendment at issue when the law enforcement is looming or threatening to enter a house of worship.
ICE and CBP have always had authority to go into places of worship when they have a judicial warrant. What the kind of statutory and regulatory framework provides for immigration enforcement is much more expansive powers than what you would see in the typical criminal context, where regular law enforcement need a judicial warrant before they're going to enter a place of worship or a private home. ICE and CBP will do something called an administrative warrant, where they write themselves a warrant under statutory law, and then all sorts of other enforcement actions. So it's not just about raids or arrests, questioning people, setting up surveillance in parking lots, all sorts of things that they are empowered to do under the immigration laws. But as you said, have not done that with respect to places of worship. And the reasoning was that those are sensitive locations along with schools, hospitals. These are places where there's a real personal and societal cost if undocumented people aren't able to go to them. Hospitals, obviously, if people can't get healthcare, education, and then really the policy recognized that communal worship and communal religious activity is at the core of the human experience. So if we were to put undocumented people and the people who care for them and or who are in community with them in a position where they couldn't come together and engage in those religious activities, that there would just be a profound, again, personal and societal costs. And so both Republican and Democratic administrations up until now recognize that.
That sort of supplements the First Amendment. What does that say, and how does that offer perhaps additional protections that the pure First Amendment claim does not?
The Religious Freedom Restoration Act was enacted by Congress in the early 90s in response to a Supreme Court decision that said that the free exercise clause of the First Amendment, which protects religious exercise, isn't offended by generally applicable laws. And I think Congress viewed this as not robust enough in terms of protecting religious liberty. So what the RFRA does is declares it an affront on religious exercise if the federal government has a generally applicable law that it applies in a way that substantially burdens religious practice without a compelling interest. And even if there's a compelling interest, they have to meet that interest in the most narrowly tailored way. So when you have here, generally applicable immigration statutes and regulations and policies, what RFRA says is you can't exercise that authority with respect to places of worship and religious communities if it would substantially burden their religious practice. I think that the notion that it burdens religious practice to have armed agents swooping in the middle of worship services and other sorts of ministry is pretty self-apparent. And so then the question becomes, the government has an interest in enforcing its immigration laws. Is this the most narrowly tailored way to do it? And the answer is obviously not, because for decades they haven't been doing this. I mean, can I just talk about one example that happened the Sunday after inauguration? ICE agents showed up at a church in Georgia during worship services. They were looking for a man who had an ankle monitor. He and his family had crossed the border, immediately turned themselves into ICE agents into CBP a few years ago, and had been given a date to appear before an immigration court. He had attended all of his required asylum check-ins. And according to ICE, this is according to what was in Christianity Today article, they pinged his ankle monitor, figured out that he was in his church service, and they showed up in the middle of the sermon while his family was with their church community.
People of faith celebrated in some corners the Hobby Lobby case. That was a case in which an employer on religious belief did not want to offer certain abortion related medication. And the court held that that's fine, that it would be an impairment of the owner's religious liberties. So the same principles that are protecting the Hobby Lobby company and owners is protecting all of us from these kinds of religious intrusions. Let's go to the last item, because this relates to many, many other lawsuits that are being brought against the Trump administration. And that has to do, it sounds obscure, the Administrative Procedures Act. But briefly explain what that means and why Elon Musk or Donald Trump cannot, without notice, just change the rules overnight on us.
Essentially, the APA requires the executive branch to engage in reasoned decision-making particularly when it changes course, when it changes from one policy to another. And what that reasoned decision-making looks like can change depending on what the agency action is, but it certainly requires more than what we saw here. It was the very first day of the new administration. And in fact, the memo rescinding the prior policy wasn't put on the DHS website. It still isn't there. It was announced by Fox News that received a draft of the memo that it was being rescinded. There was a press release put up, and it essentially just said, we're abandoning this policy because I think it had a reference to going after criminals and murderers in churches. Well, that makes no sense at all, because under the prior policy, you could always go into places of worship under exigent circumstances or with the judicial warrant. So it really was a completely unreasoned press release. Press release is all we have. So I think that's a pretty blatant violation of the APA, and we're seeing that with a lot of the new administration's actions. They're not undertaking kind of the normal steps you would expect, and it's unlawful. And I think we're going to see courts recognizing that.
And this is more than an administrative crossing the T and dot the I. If you have to give notice, you give an opportunity for the community to register objections. You would have heard from faith leaders, and the decision might never have been taken or might have been narrowed substantially. So this is more than some kind of technical loophole that we're holding up for the administration to jump through. In our final minutes, tell us what you would like the courts to do. If you prevail, what do you see happening?
We have a number of remedies at the end of our complaint. I mean, essentially, the sensitive locations policy, having that put back in place would do most of the work. There is one piece of it that I think is potentially problematic, is that under the sensitive locations policy, there was an exception if you received high-level written supervisory authority. Then you could go into a place of worship without a judicial warrant or exigent circumstances. But putting that aside, the rest of the policy, I think, really accomplished what you would want to accomplish under RFRA. And so ultimately, we either want the sensitive locations policy put back into place or some sort of injunction or declaratory relief that accomplishes that.
Well, it's an extraordinary lawsuit. It shows that there is great unity out there in America across partisan lines, across religious lines, denominational lines. It's remarkable that you could get even a couple of these groups to agree on something, and you've got, as you said, more than 24. So best of luck in your litigation, and an important constitutional development. These things affect not just government workers, not just people in other places, but really anyone who who belongs to a place of worship. We're talking about a fundamental American right to practice one's religion without fear that the government is literally going to come through the doors to disrupt your faith service. So thanks so much, and we'll check back with you and see the progress of the lawsuit.
Thank you.